All right, good afternoon, everyone, and thank you for joining us for our last of the 2017 MSHA webinar series. Today we'll be discussing miner and mine managers' rights, and that will also include the rights of the mine managers as representatives of the operation. As usual, your voice on the recording is Nick Scala. I'm the chair of the MSHA practice group at Conn Maciel Carey, where I work with operators, independent contractors, all around the country with respect to dealing with MSHA investigations and inspections, as well as all forms of contest, whether that's citation contest or jurisdiction or in agent liability or discrimination cases. So today we will be discussing several different aspects of rights under the Mine Act. So obviously we're going to be looking at what rights do miners specifically have, both rank and file and members of management, because all are considered miners per the Mine Act. We'll also discuss rights during the inspection process, as well as some strategies for handling MSHA inspections. And then we'll finish up going through some of the recommendations that I would have for members of management in particular during a special investigation by MSHA under Section 110C of the Act. So with that, we just want to start off on a very broad basis in that what are our rights and who do these rights apply to? Well, under the Mine Act, all miners are protected and have the same rights, and that includes all persons, including supervisors, contractors, construction or demolition workers, truck drivers, working at a mine site are considered to be miners. And, that's an important distinction because oftentimes when we think about the miners' rights or when MSHA comes around and speaks to persons at our operations on miners' rights, it's focused on those non-managerial employees. And the rights extend also to those members of management. We want to keep that in mind because as members of management, we do carry or it's possible that we carry additional liability, but nonetheless, we have the same rights to interact with MSHA as any other person on the site, and we should be aware of that. And this also includes people that might not be considered miners for training purposes, in that do they satisfy the definition of a miner under Part 46 or Part 48? I'm looking at truck drivers in particular. But they're still going to be employed on the mine site or working on the mine site and have those rights and can exercise them as well. So our, understanding and our approach to working with miners and respecting all the miners' rights that come with working under MSHA, we want to be aware that that applies to anyone. And that's an important thing to keep in mind. If we're just going to start at a very broad basis, and this is, taking into consideration MSHA training materials, and we know that training on miners' rights is a required part of our training for new miners, as well as our annual refresher. And, addition to the normal rights, which we might know as, to be able to file a complaint with MSHA, to be able to work or speak with MSHA, or withdraw someone from a mine, they also have the right, all persons, to participate in proceedings before the Federal Mine Safety and Health Review Commission. And that, for example, would be citation order and contest. If they want to participate in the form of a witness or they want to interact with MSHA or the operator, all persons, all miners have the ability to do this. They also have the ability or the right to file a hazard complaint. And that can be with MSHA or another regulatory body, or with company officials. And, this is an area that has gotten a bit of attention lately in litigation, as there's some ongoing litigation regarding Murray Energy and their desire to have miners report safety and health complaints to the company before going to MSHA. And while that isn't required in terms of filing a hazard complaint, even MSHA's materials say that if a miner is going to refuse to work because of what they believe is unsafe or unhealthy conditions, they should be providing the operator notice of the condition or notifying them of the condition and giving them an opportunity to address it. That requirement, though, or that note from MSHA when looking at these training materials, it's going to be construed narrowly. MSHA wants to provide to any minor who is going to file a complaint, whether that be for an imminent danger or just safety and health violations, they're going to do anything they can to protect these individuals. And refusing to work in conditions that they feel are unsafe, or refusing to work if an individual feels they haven't been provided adequate training, are obviously going to be areas that MSHA pays particular attention to. They can make these complaints in form of writing, sending them to MSHA by making a phone call to MSHA, or by even just speaking to an inspector while they're on site. And when we're talking about these, we obviously have to keep in mind that we do not have the right to discipline someone solely for making a complaint to MSHA. We'll talk about this a little bit later, but then we're treading on the question of, are we infringing someone's right under Section 105 with whistleblower and discrimination proceedings? So, whenever we're talking about minors' rights, we have to keep that in mind. We don't want to do anything that can be construed as a violation of these rights, or by disciplining someone for exercising the rights under the Act. Particularly, some that come up quite frequently, especially if we're going through an inspection or investigation, are going to be the rights to speak with MSHA. And it's important to know that these rights go both ways, and typically we won't hear that from the inspector or the investigator. They'll let everyone know that they have the right to speak with MSHA and that they, don't have to have anyone present. But it comes around the other way as well, in that all minors, while they have the opportunity to speak with MSHA, whether by their own initiation or at MSHA's request for an interview, they also can decline to speak with MSHA. And this is particularly important if we're looking at an investigation into a serious injury or a fatality, or even a discrimination or agent liability proceeding. At any point in time, an individual can terminate a conversation that's going on with MSHA. They can decline to speak with MSHA, or they can go and sit with them. They can also have any person of their choosing with them during an interview, whether that is a friend, a fellow employee, a family member, or an attorney. And that is an important element that we want everyone to be aware of. You don't have to talk to MSHA. You most certainly can if you do want to. And if you want to, you can have someone present with you, whoever you want that to be, or you can also terminate the conversation or end it at any point in time. Like I said, this is especially pertinent when we get into interviews or investigations. And we want all of our minors to be aware of these rights, because what typically happens if we've had a serious accident or a fatality, especially in fatalities, is MSHA will come on site and they will request contact information, the personal contact information, for all minors, or all minors related to this activity. And the case law is well established. We have to provide that information to MSHA. And at that point in time, it is not uncommon for a special investigator to phone up a minor on their personal phone, or to even show up at their house. And, this is when people understandably, don't feel comfortable declining the opportunity to speak with MSHA. And even if they want to, that is again, that's fine. That is their right to speak with them. But, there is a bit of the thought, such as when a police officer shows up at your residence, you want to assist, you want to comply, and sometimes people forget that they have the ability or the opportunity and the right to tell MSHA, we don't want to speak with you regarding this. And I keep harping on, the decline, because I just feel that MSHA doesn't often outline or highlight that right as much as it is the right to talk with them. we want all of our persons to be aware of all their options, as well as be comfortable with telling anyone what they want to do and being sure of that. Another person that could possibly sit in on these interviews is oftentimes it is a minors rep, if that's someone that you have at your facility, if you have a facility that does have a minors representative. And we'll talk about then when we get to the inspection process. And oftentimes MSHA will say it can't be a member of management. And, again, that comes back to it can be anyone that the person speaking with MSHA wants it to be. And if they want it to be their manager, it can most certainly be their manager. Now, they have to affirmatively tell that to MSHA. You can't just walk in and say, I'm going to sit in on this if I'm a manager. That person has to say, I want my manager, I want person F, A, B, or C to sit in with me. But nonetheless, that is that opportunity. So when we're talking about speaking with MSHA, it's important to know that they cannot require someone to speak with them. They cannot require someone to sit down and hold an interview. If you see this going on, if you see someone say to MSHA that we don't want to speak with you, we don't want to have an interview, make sure you don't let MSHA push back and try and force them to do so, because they also cannot threaten or coerce anyone into cooperating with them. Now, I say this, and, particularly this is pertinent to investigations and where MSHA wants to conduct formal interviews. And oftentimes when, I'm discussing this kind of rights with individuals, they want to ask me if, well, does that mean we don't have to talk to MSHA at any point in time during any inspection? And while you don't have to sit down and have a lengthy conversation with MSHA, we also have to toe the line between creating the impression that no one has to communicate with MSHA at any time, because then we are getting into area of an impeding the investigation. And this is most pertinent when we're talking about, communication with MSHA during a regular health and safety inspection. They are going to try to talk to the minors. They are going to want to give information to the minors and ask them questions, and they are permitted to do that. The extent to which someone wants to interact with them is their choice, but we also don't want to create the misconception with our workforce that they can tell MSHA at any point in time, we're not talking to you, we don't want to talk to you. Obviously that's right, but the inspector has to be able to do their job, and if they get the impression that there's maybe an institutional issue where we have, as a company, instructed our personnel not to correspond with MSHA or not to communicate with them, then we're towing the line of that impeding the investigation citation. And obviously that's not an area that we want to get into, because that can have its own types of consequences from an enforcement perspective as well as an investigation perspective. So while we can decline interviews with MSHA, we have to be careful not to create an environment where we totally want to blacklist any communication, because that's not going to be a fruitful development for our inspections or for the relationship with MSHA moving forward. There has to be some obvious communication, but formal sitting down, discussing elements does not need to be part of that. Additionally, MSHA cannot require anyone to speak to them alone. And this is very important, especially when we're talking about in the heat of the moment with a fatality or a serious injury or even an agent of management conversation. They might try and tell an employee or anyone, that a manager even, that they want to speak with them and that they'd like to speak with them alone. And, again, that comes back to the point that this is, or that decision is entirely up to the person who is going into the interview. MSHA cannot require them to speak alone. They can't tell anyone that, no, we are going to speak with them alone and no one else is allowed in here. Again, and it goes back to the last bullet point on the previous page, that is entirely false. Anyone can be present during an interview. And so we want to make sure that we don't let MSHA step over those bounds. Again, it's important because we don't want to put people in a situation where they feel pressured to either communicate with MSHA or not to, and obviously whatever their choice is, they need to be comfortable with that. Also, if we're going through this interview process, as we've all interacted with MSHA at some point in time, we know that they like to take notes. And we know that they like to write things down, and if we're doing an interview, they'll even ask us to review the notes and possibly even sign them. If we're in the process of special investigation, the investigator might sit down at their computer, ask questions, print out a form, and ask you to sign it. You are not required, and MSHA can't force you again, to sign anything that they create. They also can't force you to write something and sign it as accurate. We want to keep that in mind because oftentimes, we're in the heat of the moment. Maybe we're not thinking clearly. Something tragic may have just happened at the operation, and now we're sitting in a room with MSHA and they're asking us to sign something. I'll say this for anyone, any miner or manager, we want to make sure that if we're signing something, it is absolutely correct. And I'm not saying that it encapsulates the gist of what we discussed. I'm saying, is it absolutely correct in terms of everything I said and everything MSHA said? Because these individuals, they're not court reporters. They're not trained stenographers to record every word that was said during a conversation. You will get the summary that the MSHA personnel created. So oftentimes you will see that they are writing feverishly and then all of a sudden stop while you continue talking for another 30, 40 seconds. That information now isn't being put into the record. So maybe at that point in time, you started discussing the company's mitigation or the actions that you felt were not in violation. And that may or may not be going into the record. So if they ask you to sign that later, you are going, and if you do sign it, you're certifying that what you said or what is recorded there is true to the best of your ability. And we don't want to do that unless we're absolutely sure that everything is correct. So keep that in mind. It doesn't happen much in a setting such as a regular safety and health inspection. This is more along something we see in fatality or serious injuries or special investigations. And like I said, in special investigations, you'll often get something written and printed out. So, keep in mind what is going on at that time, because you are not required to sign it. You're not required to even sit there and make the statement. But if you choose to do any of those, I would ensure that everything is accurate before you resign yourself to signing it. Because at that time, especially as an agent of management, you are certifying that it is true. So in terms of what to do during an inspection, we're all aware that under Section 103F of the Act, we have the ability, as both operators or a miner, to accompany MSHA during an inspection or investigation on our site. And this also applies if we have a miner's representative. MSHA's stance on it is that every shift should have a miner's rep available to participate in the inspection. And if there isn't one, 2 or more miners may select one to travel with the inspector. But again, this isn't required. That is typically a position that's held, especially at union operations, have a designated miner's rep. And those people do have the ability to participate in every element of the inspection, whether it's an opening conference, it's the inspection itself, it's all the interviews or investigations that may occur. And, they do this without a loss of pay. So there's no lost time. We can't, dock them time or take away their hours that they're spending. This is part of the job duties. If we don't have a miner's rep, again, we may not. MSHA will, again, and this goes back to what we were talking about earlier with communicating with miners during a regular inspection, they will be tasked with discussing safety and health of the mine with a reasonable amount of employees as they do the inspection. So, these are persons outside of management that are going to be involved in the investigation process. In terms of when MSHA comes on site, we should be getting informed that they are arriving. We should be able to have an opening conference if we so desire. We should be able to participate in the inspection, have a review of our citations if any are issued, as well as have a closing conference where, again, those citations are reviewed as well as our rights to contest as an operator are outlined. So these are opportunities that we have to interact with MSHA and to participate in the enforcement process. And, we should all be aware that MSHA is going to come on site at least 2 or 4 times a year. And when they do come on site, they don't have carte blanche to do whatever they want, as much as MSHA wants to tell you that they do. Obviously they have the ability to come on site whenever they want in terms of a warrantless search authority, and they can conduct inspections as frequently as they see fit. And they are going to do so when they come on site. And they can't, though, require you to let them walk around alone through the site. So we need to be aware of that. An inspector should not be left to walk alone on the site. We want to, be with them for both safety and health purposes, as well as to stay atop of our rights. We can, also, we want to make sure that they are not forcing their way on site without giving management the ability to come and meet them and accompany them. Now, this is something that we always, get into a discussion about, because inevitably someone has an experience with an operator or an inspector that rushes through the guard shack and tells them they can't notify anyone that they're coming because of advance notice. And that is true. Advance notice is something that both minors and management cannot participate in. And advance notice means informing everyone that MSHA is coming on site and that they are going to be conducting an inspection. But that does not give MSHA the power to conduct an inspection on their own or to come on site without giving management the opportunity to exercise their rights under Section 103F. So, what is supposed to happen is management or the person designated to accompany MSHA, whether it's a safety and health person or a mine foreman, they will be contacted to meet with MSHA and begin the inspection. There is a limit to how long MSHA will wait. They're supposed to wait a reasonable amount of time for someone representing management to get on site or to meet with them. And that really reasonable amount of time might be different for different inspectors. Sometimes you can say, well, I'm going to be there in an hour. Perhaps you can start reviewing records in the office, and then I'll get there for the walk around. It may be 2 hours, or it might be 30 minutes. They might say, well, you better get here or else I'm going to start. And this is something that we have to be prepared for. That's why we're going to want to have multiple individuals trained on how to work with MSHA and how to walk around with MSHA. But to avoid the concern with advance notice, what we need to avoid there is alerting all persons on site that MSHA is present. What they don't want is they don't want a fire drill, so to speak, where everyone's running around trying to fix things because one person, whether at the guard shack or at the scale house or the mine office, got on the CB and said, MSHA's here, come on up to the office to meet them. And then everyone starts going around trying to hide things. That's what MSHA's trying to avoid with advance notice. Advance notice is not violated if we're contacting a specific individual. So, we want to tailor the announcement to, most likely a phone call, not using radios, and only to those who need to know to begin the inspection process. I see a question, and that is, are third-party consultants allowed to accompany inspectors? That is at the discretion of the company and the inspector. Typically, if the company wants the consultant to be a representative for the purposes of safety and health, they will be granted the opportunity to accompany the inspector around the site. But that is also something that can be limited based on the size of the inspection party. MSHA, does not want to have inspection parties of, many persons walking around the site because they don't believe that will be conducive to conducting an efficient inspection. So, if it's maybe the consultant is just an addition of one person to an already small group, I don't think it should be an issue. If the company wants you to be a representative for the purposes of 103F, you're going to have to get them to say so and inform MSHA of that. But, there's not a hard and fast rule that consultants are not permitted or that consultants have a right to be there. Now, if you are a contractor on site and it's possible that you may be inspected as a part of the inspection, then you have the right to accompany MSHA as a contractor as part of this 103F walk-around right. But if you were just there as a safety and health consultant for the operation, it's the question is going to be, what size is the inspection party? Will this inhibit the inspection process? And does the company express that they want you to be part of that party? So when we get to the point that MSHA is on site, how are we going to prepare for that? Well, in addition to any other preparations we do, we want to identify who will accompany MSHA. And, talked about this on the last slide when we were talking about advance notice, because we want to have, one, multiple people trained for it, and also those people identified so we know who to contact to get someone up there to accompany MSHA in a short time frame. It's important, we don't want to have, depending on the size of our operation, we don't want to have any confusion about who is going to be called. We want to outline this with our people that may be the first to intercept MSHA. Again, those people at the guard shack possibly, or at the office, or at the scale house, whatever the gathering place could be. We'll want them to know who to contact, and if that is a member of management, that management should know if we have a minors rep who that person is so that they can get them and bring them to the inspection as well. We should have all these people trained on the importance of what they're doing with MSHA. And what I mean by that is, they are accompanying MSHA, and they are going to be considered, if they are a member of management and the management's representative, they are likely going to be considered an agent. And they need to know what that means to be an agent of management in terms of additional liability. They also need to be prepared to both document what is going on during the inspection. We want them to be able or to be educated on the standards so that if a discussion needs to be placed about the appropriateness of what MSHA is alleging or the citation that they're pointing out, that they can make a sound argument from a position of knowledge about what is being discussed. This is part of it is going to be taking notes. We already talked about how MSHA is going to be writing down this entire process. And especially from a contest perspective, we want to be able to have our own notes or own contemporaneous recollection of events from this point in time to recall back to. Now, if you are just taking notes in the normal course of business, these aren't going to be privileged, so MSHA, could get a copy of them through litigation if you contest something. Or if we were taking photographs, those aren't going to be privileged either, so MSHA could get copies of the photographs. So it's important to, while not only putting our position into the writing, not making admissions that could hurt ourselves or not taking photos that might capture safety and health violations and putting those into our file. We want to, if MSHA is alleging a citation for guarding and they're snapping a photo in the hole, we want to step back and take one that might show that this is a 2-inch hole on a 3-foot by 3-foot guard. That kind of information will, be part of our walk-around rights or exercising our walk-around rights, and can also put us in the position to exercise our contest rights later on and more efficiently doing so. In addition to having, a camera, a notepad, some of those very basic items, and everyone's got a camera nowadays with their phone, we also want to make sure that the person, again, is aware of the regulations and maybe even has a copy of it. MSHA will always have their little book of regulations that is, a few inches wide by a few inches tall, and it's got the green spine on it that they pop out and flip through. We can get those for ourselves, or you can download the MSHA regulations to your phone and have them in there. And, so that is another good resource so that we're prepared to discuss things with MSHA, as well as, if MSHA is alleging a violation of something that we know to be untrue, that we can counter at that time. So as I said, for the purposes of agent liability under Section 110C, if you're accompanying MSHA on site, you're almost always going to be considered an agent of management for those purposes. And that is important because not only do you have the opportunity to bind the company with what you're saying, but if you are admitting to negligence or if you're admitting to knowledge of a violation for an extended period of time, you're also opening yourselves up to that agent liability, and whether it's additional civil penalties against you as an individual, or even in egregious situations, which are very, very rare, criminal penalties. So oftentimes, if we've seen the notes that MSHA takes, or if we've seen their citation documentation in the course of litigation, or by having requested the notes and photos from an inspection via the Freedom of Information Act, or FOIA, we can see that their negligence determination is very, very often, almost always tied to something that management may have admitted to or somewhat admitted to during the inspection process. So if we look at that, on the citation itself, negligence is simply a checkbox. Whether it's low, moderate, high, or reckless disregard, it's checked. And unless we're working with an unwarrantable failure, where it specifically has to include language about what agent did what to create that aggravated conduct, we don't see why MSHA alleges the negligence they do. Well, if we get the inspection documents, we'll see that they have to write a little sentence or two about why they're issuing the negligence they are. And, as I said, almost always that's going to be based on something that, management said, especially if we're looking at high negligence or something along those lines. So we want to keep that in mind, and that's why we're going to have notes so that we can, write down about a discussion that was had with MSHA. Now, an important element is that MSHA, in proceedings before the Federal Mine Safety and Health Review Commission, can rely on hearsay evidence to support a violation. And what that means is, we've all probably heard watching Law and Order or something that hearsay is not admissible. And while, in the context of criminal proceedings, that's very true, and even most civil proceedings, in terms of MSHA litigation, hearsay, which is I'm testifying to something that was told to me by somebody else, so it's not coming from the person who said it, it's coming from me who heard it. That's why it's hearsay. I heard it and now I'm saying it. That is accepted for the purposes of establishing a violation. So MSHA might sit up there on the stand if we're contesting something and say, well, the mine foreman told me that this was the case. And then we're probably going to have the mine foreman, if we're contesting something, sit up there and say, I'm going to tell him that wasn't a case. And MSHA is going to point to their notes. And if we, obviously we want to have other people around, if that's the ideal situation, to say that we agree with what our foreman is describing as the events of leading up to this citation. Also, if we have taken notes regarding the inspection, those can be used as a contemporaneous recollection, which, can be counter to what MSHA is offering. So, these statements, we want to be aware of what we're saying to MSHA. Oftentimes we hear of situations where, maybe things got a little contentious with the inspector. Maybe we really disagreed with a citation that was being issued, and all of a sudden we are, in an argument and saying something that is either not truly what we meant or taken out of context. And those situations, obviously, they dig us a hole, and we got to try and get out of them. So we want to avoid them if at all possible. That's why we want to be prepared to document during that. We want to be prepared to know our rights and exercise all our rights, and also we want to be, knowledgeable about what we're dealing with. And, I think one recommendation that I'll make that applies to any interaction with the agency is it's not fruitful to argue with an inspector, especially while they're on site. You can have a healthy discussion regarding, a factual situation or regarding your interpretation, but avoid taking it to the level where you want to be considering it's going to get considered as arguing, because that doesn't typically work out well for operators, because MSHA can just start issuing citations and then we're in the hole of fighting back from that. If we're looking at our contest rights, we have the right, obviously, to contest any citation or order issued by MSHA. And that's not just 104As, that's not just 104Ds, but that includes imminent danger orders, it includes failure to abate, it also can include the scope of withdrawal orders or whether they were required at all. Now, obviously, we need to know about the methods through which to contest those, and all of those that are listed, you're going to want to file a notice of contest within 30 days of issuance with the commission. But many people think that, I just don't even have the opportunity to contest this, and that's untrue. You have the right to contest anything that MSHA issues. You can do this whether you take advantage of the pre-assessment or the informal 10-day conference, or you can contest it formally once a penalty is assessed. Now, I would say that the ones listed on the screen right now, you might not get a penalty for a 104B. You won't get a penalty for a 107A or 103K. So your opportunity to contest those is through the informal process in the 10-day with a pre-assessment, or formally, but you have to file that notice of contest within 30 days of issuance with the commission, because normal contest proceedings begin when you have an assessment in hand. You get that document from MSHA that says, hey, here's your penalty. Let us know if you just want to pay this or if you want to contest it. You're not going to get that opportunity for the items listed on the screen, so you want to make sure that you try to contest whether it's in that 10-day conference or by doing the 10-day conference and filing a notice of contest. If we're going to look at additional protections of these rights, we're looking at what is Section 105C of the Mine Act, and that is MSHA's Whistleblower and Discrimination Protection Statute. So, we've outlined a lot of rights here that miners and mine managers get to exercise if MSHA's on site. And, if an operator violates these rights, or a miner believes that an operator has violated these rights, they can file a discrimination claim against MSHA. And it protects against discrimination for miners doing things such as making a health and safety complaint, refusing to work because they believe in unsafe conditions or they don't have inadequate training, those items that we listed before. And, when we're talking about a discriminatory action, there has to be some adverse action taken against the individual. And when we look at the list of what MSHA considers an adverse action, it's really very, very broad. It can be, the obvious ones, just discharge from employment or layoff, or it can be something like reduction in benefits or rate of pay. It can be as simple as changing hours, maybe putting someone on a different shift, or transfer to a less desirable position. Those are, examples, and just a couple of the examples that are considered adverse actions by an employer against a miner. And also, it's important to note that these rights apply not just to people in our employ, but also applicants for an employment. So, this does have the ability, if someone feels that they are getting discriminated against during the application process, they can even file a claim under this. And if someone's going to file a claim under Section 105C, they're going to do that with MSHA. It has to be done within 60 days of the adverse action or coming to realize that it was an adverse action. They do give the individuals a bit of leeway in that regard. And at that time, MSHA will investigate it. And the agency will actually determine whether or not they are going to take the case up on that individual's behalf, meaning they're going to act as MSHA's attorneys, or MSHA is going to act as that employee's attorneys, or if MSHA doesn't take the case up, the individual can still pursue the action on their own. And in doing so, one big difference between MSHA taking a case and the individual taking it on their own with their own attorney or just on their own pro se is temporary reinstatement is available and most likely will be granted if MSHA decides to take a case. And what that means is if you have discharged the person or, again, switched from duty to shift or changed their payment or their salary or something along those lines, they are going to be made whole until the proceedings are resolved. And so that means if someone has been laid off, you're going to have to bring them back to the workforce, or you're just going to have to pay them to not come back. So, obviously we want to avoid these situations. MSHA takes discrimination claims very, very, very seriously. Oftentimes, if we're working with a special investigator on a 110C case, the events or the interviews will get pushed back because these 105 cases takes precedence in terms of timeliness and looking into the investigation. So we don't want to get into this situation. The same rights are going to apply with regard to working with MSHA and communicating with MSHA, but the repercussions could be serious in terms of what the company may owe the individual if it is found that discrimination took place. It is also possible that if an individual manager acted egregiously in the discrimination, that they could face additional liability under Section 110. So the 105C is really MSHA's tool for defending the rights that we've been reviewing today, and it is something they take very seriously. And we've seen across all industries in the last few years a big pickup in the defense or the discrimination cases that the agencies have been taking on. Another right, and MSHA not only requires us to provide training, but it's also considered a right under the Act, is to provide adequate training to individuals on our site to safely and healthily conduct their work. And as we talked about before, if a minor is not trained, they will be withdrawn, or if they're not adequately trained, they will be withdrawn by MSHA if it comes to their attention. In addition, the minors can withdraw themselves if they don't believe that they were adequately trained or do not feel comfortable with training to get additional training before they go back to work. And that can be whether it's additional training on a specific task, or if it's people coming on site, site-specific training. We don't want to forget that for Part 46 operations. It's also the right of all individuals who are minors to be compensated for time spent training, and that's an important element. We don't want to get in a situation where we are requiring people to do training but not compensating for that. And that includes anything as a time spent training, as well as if someone is going off-site to hold your training, maybe at a different location. Maybe it's a location that's big enough. We do have a right to provide compensation that might be lodging or mileage in terms of gas or meals that individuals have to take on, beyond the normal scope to take part in the training. So, this usually isn't a concern because most times training takes place at the mine or at another facility of the company's or a very nearby one. But if the event arises that you're sending someone out of state to get caught up quickly onto training, we would have to compensate them for not only the time but the travel and any other expenses incurred. The training violations, training rights, this also pertains to information and education subject to the HAZCOM standards in Part 47, which is going to be alerting people to what hazardous substances are on site, the risks that they might suffer from coming in contact with those, as well as any other information that we're required to provide under Part 47. So it's not just our new minor training, it's not just annual refresher, it also goes beyond that. If we're looking at the recommendations I would have for, operators that may be undergoing or subject to special investigations, to give you a bit of background, these are how MSHA can investigate individuals. Now they do, conduct 110s pretty regularly, especially if we've had an accident or a fatality or an unwarrantable failure, 104D issued on site. We have to be prepared for a special investigation to take place. Another way that can be triggered is a high negligence training order. And while none of these are automatic triggers, most of them are going to create a need or a prompt for MSHA to review the situation to determine if they should conduct an investigation. And again, for agents of management, these investigations can result in additional or civil penalties against them personally, or again, in very rare situations, criminal penalties. And when we look at criminal, we're looking at instances where we're knowingly falsifying documents or providing false information to MSHA, or knowingly and willingly putting people into very, very dangerous situations. So again, those are very rare. Typically, when we're looking at 110, we're looking at the possibility that MSHA may issue a fine against an individual. And if that is the case, if we're going through an agent investigation, I have recommendations that I offer to members of management or agents of management that might be going through this process. Obviously, if I am representing a company and I'm representing an agent of management, or if I'm representing a company and the services are made available to the agent of management and they agree to that, I'm going to recommend that you not sit down and talk with MSHA alone, that you have an attorney present. I'm going to recommend that you don't provide written statement or sign a written statement, as we talked about previously. If you don't have a previous engagement with counsel, maybe your attorney has someone in-house or they have another outside counsel that you work with, I would recommend that you get in contact with counsel of some sort to discuss your options moving forward during the investigation. If we have a 104D issued, typically those are going to have a named individual as the agent that actions constituted aggravated conduct for the purpose of issuing that. I would recommend that individual, again, this is why we want to have multiple persons trained to accompany an inspector, but that they, sequester themselves from the remainder of the inspection, as well as the closeout conference, because anything that is said is going to be written down, as we talked about before, and can be used as evidence to substantiate that unwarrantable failure. A very, very straightforward, but nonetheless very important item is we cannot and we should not attempt to influence our employees during this process, whether that is to influence them against working with or not working with MSHA, or to get their stories in line, or to create a dialogue for them to follow. Those are all situations that are going to get us in a position where we might be looking at now criminal actions. We don't want to stomp on the rights of anyone. In addition to that, we might be looking at whistleblower complaints at that point in time. So those are straightforward. I know all of you are never going to do any of that if this situation arises, and you all wouldn't know that even without me talking to you right now, but nonetheless, it needs to be said. If there is a 110 that comes on site, be prepared that MSHA is going to ask to question you. And if they don't question you or all the minors on site, they can request to interview agents of management. They can request to interview minors. So everyone should be prepared for that eventuality. Everyone has to be willing to tell MSHA that they don't want to talk with them or don't want to be interviewed if that is their decision. Also, they need to be aware of the rights that we discussed earlier, that they may talk to MSHA as they see fit or have anyone present with them when they do. I'm going to beat a dead horse here, but do not sign a statement unless it's 100% correct. And if you are an agent of management and subject to the investigation, I'm going to, if you're my client, I'm going to counsel you not to sign the statement no matter what, because, as we said, these investigators, these MSHA inspectors, they're not stenographers. They're not going to capture every word that was said in that discussion. We want to make sure that the statements that we sign are 100% accurate. So with that, I appreciate everyone jumping on today. I'm happy to take more questions if anyone wants to type them into the box. Please check out the report. And while we are finishing up the 2017 webinar series, we will be having a 28 webinar series as well. You guys are getting the first glimpse of it right there. We will broadcast this, this week or next week out to the entire industry to see who wants to sign up. It will be the same process as we had for the 2017 series. So I hope that you will take part and join me on those. So if there's any questions, I encourage you to go ahead and ask them, or if you don't want to ask them on the webinar, please feel free to contact me by any means listed on the screen, and I'm always happy to discuss any questions with you guys. All right, it looks like we don't have any questions at this time, so I appreciate everyone jumping on today. Have a very, very happy end of the year and holiday season, and Happy New Year, and we will talk to you all again in January. Thank you.